For judgment, item number document 22 of 25.
Respondents, no one. We have dismissed the application.
My lord.
We are inclined to hold that the order impugned is supported by sufficient reasons and does not call for interference by this court.
All right. Short form and it will be difficult for this Supreme Court.
Item number 2, Deputy 8 of 125.
Since the appeal has been taken out after plea, this is.
Section 5.
Yes, this needs to be served.
You have not served.
No.
The appellant is directed to serve copy of the application under Section 5 of the Limitation Act upon the respondents and file affidavit of service on the adjourned date.
Next to you.
The matter be placed before the next available circuit bench.
Amen.
Yes, the state.
State? Okay. Take state.
Where is the state?
That was the one.
My lord, I am appearing for accused number 1, Mohammed Wasim. And
Yes.
Yes, ma'am. My lord. My lord, he has been arrested on 3rd of August.
Please give you a minute. I'm waiting for the state actually. I do not find the state.
Okay, my lord. Okay.
Let these be passed over at the state. Oh, of course. I mean, all these.
The bail matter been passed over.
No, the other matters also the same state person is appearing. So
Yes,
let, wait, just 2 minutes. Let him come. I'll take it up.
Grateful. Grateful. Okay, my lord.
Item number 5, WPS 339 of 125.
My lord, I am appearing for the petition, my lord.
Yes.
Respond number 1 and 2 is there. Report.
Who is appearing for respondent number one?
Stand for the respond number 3.
Now, what about the?
Sumit Karmakar, for 2, Babita Das.
Where are they?
No, copy was also supplied to us.
Is that matter for compliance?
They file, my lord, the copy is served upon us, we will.
Passed over, I'll call, let there be a second call today.
Item number 6. WPA 348 of 2025.
I'm paying for the petition, your lordship. This is the case of the issuance of transfer.
Where is the respondent? Passed over.
Item number 7. WPA 356 of 2025.
মনোজ এটা কি 24 গরম লাগছে
Item 7.
ফাইল দেখি Item 7, no one.
Your lordship, I am appealing for the petition, your lordship.
In 7, opposite part, the respondents passed over. Let me see.
Item number 8. WPA 390 of 2025.
Petitioner,
I'm paying for the petition, your lordship.
you are for the respondents.
Your lordship, this is similar matter, your lordship, of the value added tax.
That's section 32, 33. Same order will be passed. You have a copy? You have a copy, same one. Yes. It will be decided on affidavits.
Yes, sir.
Item number 9. 392 of 2025.
Your lordship, item number 9, 10, 11, 12, 13, and 14. See.
We are sure it's the same, right? So the same order
Your lordship. Same issue, your lordship.
till 14.
Till 14.
Item 10, my lord, I got a copy.
Yes,
Item 10, I don't have a copy, I have a copy.
you have a copy. So till 14, the same orders are being passed for exchange of affidavits.
Item number 15.
Outline.
WP 267 of 2025.
Yes,
But there is a direction to file affidavit in opposition.
yes.
The last direction was issued on 28/7/2025 for 1 week.
You've not received a copy as yet?
Your lordship, my senior is Bhavita that is hearing for.
Yes, where is the affidavit in opposition? You've not received a copy?
No, your lordship. Lordship, let it in the next circuit. In the meantime, I'll file my reply.
Are you filing? At least that come on board. Court mein file hua?
Yes, sir.
Where is it? Manoj?
In 30 July. 30 July I filed them.
No, it's not in the file. It's not in the file.
30 July.
Order to কি করবো তুমি? আমি রেকর্ড করছি তো ফাইল হচ্ছে। You're sure you please check? Give me 2 minutes, I'll just check. But I do not find it in the file. Let it be passed over for 2 minutes. Just to talk, আমি এটা হলে অর্ডার করছি।
Item number 16. Here on of 123, it is grant 2 of 125.
Here, my lordship, I am appealing for the complainant.
Yes,
Here, the matter that
Proceeding will, was an appeal under section 138 of the Civil Instrument Act.
yes.
The accused was acquitted, but in appeal, he was convicted matter, it was reversed. After suffering an order of
judgment of conviction, my lord, he had come to me for moving the SLP, my lord, but I had advised him to get the offence compounded having regard to the materials. So luckily both the parties have agreed, they have
Agreed.
compounded the offence.
We have
my lord.
received the payment.
That may be recorded and the judgment of conviction recorded.
There should be an application to that effect.
It's there.
Tran two.
The appellant has received the money, he has both
You are appearing for the accused.
accused.
And for the complainant, my lordship.
And for this state.
We have received the payment, my lordship, as per the,
The entire payment you've
yes,
received.
my lordship. We settled for 13 lakhs, that was received, my lordship.
The complainant slash respondent lodged a complaint against the
This one.
accused slash appellant
Oh.
before the learned judicial magistrate, first court, Port Blair, under section 138 of the Negotiable Instruments Act, which was registered as CR case number 128 of 2017. Stop. The accused appellant was acquitted from the charges therein by a judgment delivered on 28th February, right? You were acquitted?
Yes, my lordship.
28th February
28th February
2023. The judgment was carried in appeal before this court. Stop by an order passed on 14th July 2025, this court reversed the judgment of the trial court, the learned trial court, and convicted the accused appellant for offense punishable under section 138 of the Negotiable Instruments Act and sentenced him to suffer simple imprisonment for 1 year and pay fine of rupees 15 lakhs, in default to suffer further simple imprisonment for another 6 months. The present application, being CRAN 2 of 2025, has been filed by the parties. It's a joint application?
No, my lord, only the appellant. Basically, the appellant says that he has compounded the offence and he has received the payment.
By the accused appellant, wherein the appellant states that the offence has been compounded by and between the parties under section 147 of the 1881 Act, and the entire amount has been paid by him to the complainant respondent. Stop. Learned counsel for the complainant respondent concedes to the submission made on behalf of the appellant and submits that the entire amount has been received by his client. Paragraph. In view of the above, this court is inclined to hold that since the offence has been compounded by and between the parties upon payment of the entire amount due, the judgment dated 14th July 2025 delivered by this court convicting the accused appellant is set aside / is set aside. The accused appellant be set at liberty at once and be discharged from his bail bonds. Tran 2 of 2025 is disposed of accordingly. Urgent certified website call. The past over notice. In item 15, I'll pass an order. There's no one. Affidavit in opposition filed by the respondents is taken on record. Paragraph: on prayer of the petitioner, liberty is granted to use a reply to the affidavit. Paragraph: the matter be placed before the next available circuit. Yes, the passed over matters.
Passed over matters. Item number 1, declare came on of 2025.
Please, my lord.
Yes,
We are seeking indulgence of the Honorable Court. Invoking the inherent powers of the Honorable Court, my lords. The parties have arrived at a mutual stand. The MOU has been placed on record as per instructions of Lady Sir, and yesterday itself. And this is subject to certain compliances, Malaysia. So at this juncture, our request is only this, my lords, that subject to the compliance, the matter will be signed, dine, adjourned. And we can take the proceedings further, and the proceedings may kindly in between meanwhile be stayed.
let me deal with the bail application first. Yes.
Ladyship.
Yes, my lord. My lord, I'm appealing for the accused number 1, Mohammed Wasim, who has been arrested on 3rd August and
You are-
he is in custody since then.
Right, not in the bail application.
We are not members. So the bail application is
Yes,
done by
yes,
Mr.
Leonard Counsel is appearing for the petitioner. Yes.
Yes, my lord. So, my lord, I am appealing for accused number 1, Mohammed Wasim, who is in custody from 3rd of August. And my lord, he doesn't have any involvement in this case, apart from the fact that he is in a directorial position. And my lord, the main thing is that the parties have arrived to a amicable settlement, and the MOU has already been placed before your lordship, my lord. So, my lord, since there is no justification for his further detention, I am praying for his bail on any condition, my lord.
Let me hear the state.
I the inputs of, because I will be, it's not recorded on the matter. As of yesterday, his PC is concluded, he's been sent to judicial.
I've seen the orders. Yes.
So there is no custodial interrogation per se that has been pressed by even the
Prosecution.
first.
I've seen that.
And passports have been signed.
Yes, the state.
Lordship, on the basis of the written complaint of the complainant that he had been, some money has been taken, that is cryptocurrency, 162 crores. As per the written complaint, the 100 crores have been refunded and 62 crores not refunded. Then on the basis of they are not repaying, digital conspiracy is there. Thereafter, FIR have been lost. He is not a permanent resident of this island. FIR have been lost against 6 persons, lordship.
Yes.
These accused persons were arrested on 3rd August 2025. Then he was taken in police remand. Yesterday he was produced, again he was sent to the judicial custody.
What is the result of the police remand?
Lordship, the IU is present, lordship. Some seizure was made, passport was retained.
Passport he undertook to
Lordship,
surrender.
some seizure was made.
What seizure was made?
Mobile. Only mobile. Only mobile have been seized. Only mobile have been seized.
Anything found from the mobile?
That has to be verified.
That has to be verified from the
MOU, the memorandum of
Lordship, I have gone through. But at this stage, Lordship, because during investigation, prima facie, some other 2 or 3 complaints, information have been received that some huge amount have been lifted by the complainant. That part yet to be.
Where is that information? Please show me.
Lordship. I am showing Lordship, just.
And he's a resident of Port Blair.
Wasim is the resident of Port Blair.
So we are dealing with Wasim now. Bail petition is only by Wasim.
Wasim, Lordship.
Yes,
Sorry,
my lord.
I have said that he's a not permanent resident. But in respect of there is a chain, Lordship. 4 accused persons. This Wasim, with the help of the mother, he is the director, mother is the joint director, performer, and other 4 to 5 accused persons there.
The complainant was cheated, right?
Complainant not only cheated, Lordship, kindly appreciate this part. During investigation, he was cheated, memorandum of settlement have been filed, that is a fact. If at this stage, Lordship, because on 3rd August he was arrested. We are on 8th
Why
August.
do you require his further custody? Only because 3rd August and 8th August, that cannot be
No,
reason
that
for
cannot
further
be taken
custody.
into
Why
consideration.
do you require his further custody?
Lord, the other more accused person is because thorough investigation is required. Because at this stage, if you will come out from the bail, Lordship, chance of hampering and the tampering of the evidence, Lordship. That is the main.
These are documentary evidence, right? And they are already in your custody.
Lordship, that is true.
The case is, if everyone,
Lordship,
sir.
Lordship, there is a chain, Lordship, between 6 as prima facie found.
Chain between whom?
But to 6 accused persons.
Yeah, they are-
Between Wasim, director of that company, that who
They
have.
are all accused, right?
Four are accused, named accused.
You have not arrested any of them and they are cooperating, they are appearing before you.
41, they are absconding. 41, a notice was given, Lordship. Upon them, they are not coming forward.
What do you have to say about the MOU?
Lordship, that is settlement, Lordship. We cannot deny it because the complainant signed it, Wasim and other person also
I
signed
am
it.
quashing the cases. now.
Lordship.
His further detention will not be required in view of the settlement.
My
also.
respectful submission, of course, required. Maybe recorded, Lordship. Lordship, my custody, interrogation is very much required. Every chance for influence the witness is concerned, Lordship.
Primarily, my lord,
Because
this is a case for-
huge misappropriation of money, public.
On a primal note, my lord, these are all people from IT background. This is where the miscommunication has happened. And it's a virtual digital transactions. And they will abide by the terms. They're stating that they have put the funds in the market. They'll get back into the complainants.
My lord, my humble submission is that my client Wasim, he has no involvement in this case. And the principal accused number 6, Ravinder, he is still, he has not been arrested. So, and the matter has been.
Mastermind. That's
Yes,
what I find from the.
Yes, my lord. Yes, my lord. And the matter has been already amicably settled. So I don't think there is no justification of keeping my client under custody.
It is a fact, what is within the case diary, I have
The
submitted.
petitioner, learned counsel for the petitioner submits that the petitioner is in custody since 3rd August, you said, right?
Third.
3rd
3rd
August.
August. 3rd August, my lord.
He has no involvement in the alleged offense. Stop, moreover, comma, the parties have decided to amicably settle the dispute between them and a memorandum of understanding has been signed and filed to that effect. The petitioner seeks bail. Paragraph opposing the prayer, comma, learned counsel for the state submits that the petitioner is part of the racket which has duped the complainant of several crores of rupees. You said how many crores?
160.
160, rupees 162 crores, out of which 100 crore, in the form of cryptocurrency, right? In the form of cryptocurrency, out of which 100 crores have been returned. 100 crores have been, approximately 100 crores have been returned to the complainant.
My lord, this should not come on record because this is again a typical
Submission.
submission.
I'm recording the
Leadership.
submission.
Leadership,
Yes.
grateful.
The petitioner may tamper with evidence and influence witnesses if released on bail at this stage. Paragraph, I have considered the material on record. Allegation against the petitioner is that he, along with the other accused persons, comma, misrepresented the complainant that they had direct allocations from crypto projects which guaranteed delivery and steep discounts. According to learned counsel for the state, out of the 162 crores allegedly cheated, 100 crores have been returned. The petitioner was taken into police custody and has been sent to jail custody since 7th July 2025. A mobile phone has been recovered from the petitioner, which may be sent for forensic examination. No other recovery has been made from him. Stop. The issue appears to have been amicably settled between the petitioner and the complainant. The petitioner and the other accused persons on one hand, and the complainant on the other. And a memorandum of understanding has been executed to that effect by and between them on yesterday, right?
Yesterday, ma'am.
On 7th
7th
July 2020.
August, ma'am.
I'm so sorry, 7th August 2025. Paragraph, considering the material available on record, extent of complicity of the petitioner in the alleged offense, as well as the fact that the issue has been amicably settled between the parties, this court is of the view that further detention of the petitioner is not required and he may be granted bail subject to stringent conditions in order to ensure his presence before the in order to ensure his cooperation in investigation. Stop. Paragraph, accordingly, prayer for bail is allowed. The petitioner be released on bail on furnishing bond of rupees 10,000 with 2 sureties of like amount each, I will not give such a small amount, let it be 1 lakh.
And this commanding.
1 lakh. 10,000 is the usual amount given, so do you get sureties of 50,000 each here? Or do I have to break it up?
Advocate.
1 surety can, because I'll give 2 sureties in that case. 1 should be local. With 2 sureties of like amount each, 1 of whom should be local, to the satisfaction of the learned Chief Judicial Magistrate, Port Blair, subject to condition that he shall appear before the investigating officer once a week till submission of charge sheet. He shall not, his passport is already submitted. He shall not leave the islands without prior permission of the learned trial court. Stop. He shall not intimidate witnesses or tamper with evidence in any manner whatsoever. Paragraph, in the event the petitioner fails to adhere to any of the conditions stated above, the learned trial court shall be at liberty to cancel his will in accordance with law without further reference to this court.
Grateful, Lordship. Deeply obliged. Your Lordship. Deeply obliged.
Lordship, just kindly.
In the declaration, the judicial custody was taken as 7th July, 7th August.
No,
Please
she
make
has-
it August. It will be done. It will be done.
Your Lordship, just one request, the name should be mentioned in the order.
The petitioner has surrendered his passport before this court, before the police. Well,
No, my ladyship had a query. Sorry.
yes,
Ladyship had a query on the last occasion.
yes.
Oh, that's the next matter. That's done.
Oh. In the CRR.
My ladyship.
Item number 2, CRR 33 of 2025.
My ladyship, just to support my lords, on the basis of the non-compoundable, may refer to one of the paragraphs for kind consideration of this honorable court, if I may read with the permission. This is para 29.7, ladyship. While deciding whether to exercise power under section 482 of the code or not, timings of settlement play a crucial role. Those cases where the settlement is arrived at immediately after the alleged commission of offense and the matter is still under investigation, the High Court may be liberal in accepting the settlement to quash the criminal proceedings, public investigation. It is because of the reason that at this stage the investigation is still on and even the charge sheet has not been filed. Likewise, those cases where the charge is framed, but the evidence is yet to start or the evidence is still at infancy stage. The High Court can show benevolence in exercising its power favorably, but after prima facie assessment of the circumstances material mentioned above, on the other hand, where the prosecution evidence is almost complete or after the conclusion of the evidence, the matter is at the stage of argument, normally the High Court should refrain from exercising its power under Section 482 of the Court. So this is a direct judgment, my lordship, which suggests by the Honorable Apex Court of the country that if right after the complaints, if the parties with no criminal antecedents per se arrives at a settlement where the dispute could be amicably settled, the court can monitor it. And subject to the stay of the proceedings and the compliances of the MOU, it can be dealt with.
The stage of quashing has not arrived as yet in terms of your MOU.
Absolutely. And
Where is the MOU?
MOU, my lordship, is just complete. At page number, my lordship, 5.
ঠিক আছে, এটা আছে।
So my laws have correctly pointed out, which is at page 5 of the settlement agreement, my lordship,
Page 3 also.
and page 3 also, right, my lordship.
So there has to be a full and final settlement of the claims.
Absolutely, it has to be subject to the compliance.
2026, I think.
Yes, my lordship,
The entire
absolutely correct.
settlement.
Absolutely correct. So deeply grateful.
B is also very clear. 5B is also.
Absolutely, your lordship.
So what are you asking for now? There cannot be a quashing at this stage.
Yes, Rachel, I'm only seeking a stay in the proceedings so that they can go back to their work, specifically work it out, comply with the MOU, and then the matter could be recalled upon.
This is basically a non-compoundable offense, right?
Malaysia.
Supreme Court has not dealt with a non-compoundable
It
offense.
has dealt, Malaysia. Kindly see, for a moment. It has been dealt categorically. Can I have the another judgment of Supreme Court where the reference of Nagan Singh made? High Court. This is another court, my lords, which the parent is. On national, no. This is, yes. What's the
Yes, the
paragraph?
relevant paragraph.
Yes, Rachel, just a minute. At page number paragraph number 17, leadership. No, not 17. When Narendra Singh is offered, is mentioned, show me that. I'll just show.
Here offense under 307 was not made out.
Leadership,
The other offences were perhaps
but I
compounded.
will.
Copy I think, sir.
Yes, the judgments.
Where
Yes.
is an explanation, Narendra Singh? एक सेकंड आंसर प्रगति है सुन I want Govind Singh versus State. Govind Singh versus State. Yes. This is, yes, can you please, I'm so sorry for the delay, Rachel. Give me a copy of this.
Here the discussion is primarily about 307 not being attracted.
Leadership, can you see for a reference para number 7 of Govind Singh versus State and others? May I read with the permission? The court has considered the submissions of the parties, while the offence under 319 plus 2 of the BNS is non-compoundable. The offence under section 3184 of BNS is compoundable. So this is a similar matter where there are sections compoundable in nature, sections
In the
non-compoundable.
genuine settlement, this issue has to be taken care of by the
By
state.
the state,
The state
absolutely.
needs to verify.
Absolutely,
right?
leadership.
So at this stage, I will let this go before the next circuit. Let it be considered, but because in the meantime, let the state verify. Please verify the genuineness of the MOU, whether it has actually been done.
Lordship.
Because there are exceptional circumstances when non-compoundable offences can also be compounded.
That was, yes, I Lordship, always before this court, Lordship, kind of this judgment in respect of 307 against the body of the human. Lordship, kindly see, there are two parts in the investigation after restitution of the affair. First part is appropriate cheated to the complaint. But second part, kindly see, Lordship, for staying the operation.
409 stands in the way, right?
Lordship,
So I'll request you to go through this, let this be dealt with then, because we are on the, at the penultimate day. Right? I wanted to deal with the bail application because it affects the liberty of a person. So let these matters be placed before the next circuit.
I have also judgment that the grounds of settlement cannot be taken It's for quashing of their fact.
Exactly, that's the reason why I say that let this be placed before the next circuit, let the next circuit bench deal with
No
it.
stay loss.
This has to be dealt with it.
Leadership, I understand that, but my only humble submission is this one.
One submission of. There are different both ways. But now we are arriving to the settlement, but we have to make a payment in another 30 days. But now,
Make your payment, nothing is being stayed.
please, not now at this point of time, what has, we can argue, not till that time, not in case we have not been stayed, not to reach the first stand itself. We can plan, because we were there in the investigation, we have cooperated for the police, they have taken 1% to the custody, where it's been 3 days, nothing will be trampled, because everything is online.
What are you asking for, sir?
We are only seeking stay proceedings, my lordship.
No, no, proceedings will not be stayed unless this is verified. No, we need to see whether, this is a 409 case, sir, you must understand. Proceedings will not be stayed.
To show my bona fide, in case I make the first transfer of payment, that is the bona fide what I can show to the.
Monday is the last day of our circuit, right? The next circuit sits, I think, not very, it's on 25th, I think.
What's
Yes,
circuit?
25th.
What is circuit?
25th is the next circuit, so you can always wait till then, right?
Can I make?
Well, that's, if I may make a submission. Well, that's, as of now, it's, with the facts and circumstances before my lords. Because the parties are, all the parties are here.
Who is appearing for the complainant? You are for the complainant, right?
He's for the complainant. I am for, Mohammed Wasim, I am for Vaibhav Gupta. He is appearing for Ravindra.
Yes.
I am also appearing for Azhar Enterprises and Latifa. Well, as the parties have arrived at an MOU, which was notarized, duly notarized, the affidavits have been given. And whatever verification my lords had.
Circumstances.
passed and
The circumstances are very, very important
And my lord-
in such cases. You must, you are aware.
So had passed an order to verify the MOU.
I have not yet, but I think the state wants to do that.
My lords had asked state to verify the MOU.
Can that be done in a day, sir?
No, well, I'm not asking anybody to.
Please don't be-
Human here.
Please don't be
This is a
impatient.
humble submission.
Come back on 25th. The next circuit is on 25th.
Please.
Proceeding need not be stayed, let that continue.
Well, in the event, my lords, can I just request on behalf of Mohammed Wasim, now that he's been enlarged out on bail, that no further coercive steps may be taken because my.
Once he is on bail, no further courses will be taken.
Well, the problem is.
Leadership, it can be stated for the others who have surrendered their passports. Like Ravindra, he is the man. You see, we need to understand that at this juncture, let me complete. We need to understand this juncture, Malaysia. There are people with IT background. They would also require to invest their intellectual capacity of mind in order to regenerate the funds they've already invested in. If we keep on carrying on with this pressure.
I think, sir, because you need to come before the next, this needs to be heard at length,
Proceed.
right?
May I submit, Lordship, for one set? Lordship, I already stated something. There are two parts. First part is the cheated to the complainant. Second part, can you see? There is a evidence that huge amount have been taken, lifted from the market, Lordship. If the investigation.
Where is that evidence? You have not been able to show me that evidence at all. Where is that evidence? It is only from the complainant and out of which major part has been returned.
Directly
That is your
with the
submission.
parties.
Other part, where are the other evidence?
I show you. I am handing over the case. Yes.
You say that besides the complainant also there has been lot of money lifted from the market. Where is that evidence?
Data, not to stay the further.
I will not stay the further investigation. I'll only grant no coercive steps against the petitioners till the next circuit sits. That order is not there. Where is that order?
On Saturday, your lordship has passed there.
No, that order was there, valid till 7.
It was till the adjourned date.
Yeah.
So let me extend it to a limited period on 31st August.
Then I request one thing.
Lordship.
Let it be listed after the first tranche of payment, which is 30th of August.
I'll stay this order that I've passed of no coercive steps being taken.
Correct.
I'll extend that till 31st of August.
Deeply grateful.
So by then you have.
Even the matter,
The
leadership,
next circuit.
may I request in the next circuit only, the matter be listed after 31st August. Primarily because the reason we'll have something to share on the board, my lords.
No, the next tranche of payment best we have, I have to put. Not the next month, 6th. Post that one, not let the matter be put.
Leadership.
Next.
That means what happens is.
So the bona fide.
Bona fides
On the side of the accused, the complainant also has.
When is the first tranche of payment?
6th of August, September.
You said 30th August just now.
No, sorry, 6th of.
If it's being signed on 7, you have 30 days of period to make.
The first payment. So it's 6th of September.
So we can have it on 7th of September if possible.
It's Sunday, that will be on 8th of September.
Late issue,
I'll stay till 8th of
The
September.
circuit bench will be there.
late issue.
Yes,
Yes.
right, yes. Bench will be there.
We are so deeply grateful, my nation.
Give me a minute. Circuit bench will be only till 8. So let it,
It's fine.
the last day again, the same thing will happen.
Only to show the.
Only to show the bona fide and they
We are
will.
not asking for attachment on that day also.
Yes, you say.
The agreement will not say so.
You cannot.
Yes.
According to 5B and 3, you
As
cannot.
per agreement itself, we are not saying.
Yes. That's what I'm saying, sir, you cannot ask.
For the indulgence, which will face it again.
Yes, it's not your charity, you cannot ask, according to the agreement.
Ladies, deeply grateful.
That's what we are indulging. On that day also, we are not asking for the attachment or the final arguments of the case. We will.
So I'll stay this till 8th.
8th.
Mention before the next circuit.
Grateful.
No, not stay. Course, if this, I'll
No,
extend, I'm so sorry. I'll extend this till, yes.
I think August, next circuit, so.
Their first, please see the MOU. The first payment is on 7th, I think, in 6th.
Six.
First payment is on 6th. Let them show their bona fide. 7th is a Sunday. So I'll extend till 8th.
Lots.
Let them take necessary
I'm
steps.
showing that,
Right.
I will also, that email have been received.
Let me see what email. You're harping on this. Let me see. This is by whom?
Actually, what they have done is that out of the custody of the mobile
Not
phones,
often.
they had different matters, my lordships, not arising out of the present FIR.
Since I'm not dealing with it, it will be.
That part may be recorded on my album.
These investments have nothing to do with the present FIR. Those are different transactions altogether.
Supplementary affidavit filed by the petitioners is taken on record. Paragraph, learned counsel for the state seeks to verify. You want to seeks to verify the memorandum of understanding submitted by the petitioners. Paragraph, the matter be placed before the next available circuit bench. Paragraph, the interim order granted earlier is extended till 8th September 2025 or until further orders, whichever is earlier.
And the next date of hearing would be 8th September, my issue.
The other circuit will decide. I cannot fix a date for the other circuit.
Oh.
That's beyond judicial discipline. I cannot do that. You can mention on the first day itself so that it's fixed in the meantime. Other matters same, similar?
So we'll mention for the date, my leadership.
You have to.
Honorable.
One circuit cannot fix a date in the other. That's not correct.
It works with on the pattern of the Calcutta High Court primarily, I believe, the circuit thing.
Yes.
Grateful.
No, this is courtesy.
Yes.
This is judicial.
I understand.
We understand.
I bring on towards follow.
Next,
Leadership,
same, stay was granted in all the matters, please give me.
the parties have also informed me that just in case if it's literally possible to release the first tranche before 25th, maybe within we can mention. Yeah, to show the bona fides will also
For
recorded.
that, if you can, because the stay is till 8th,
Yes.
so there is no harm in doing it earlier.
Leadership,
If
absolutely.
you
I
can
understand.
sort that, you mention it.
And then we can mention.
Yes, there's no harm in that.
Deeply grateful.
You cannot cross the date, you can do it
Ladies,
prior to that.
ladies, much
So the
obliged.
same order will be passed in this matter also?
All matters the issue.
The same, in this also, there's no course of steps, this order is there? 4 also? 4, give me 4. Open as
Yeah.
This is the other 45? 34 as 45. It's there, but still I want to go through it once. Yes, so the same order in all these cases. There are other passed over matters. 5.
Okay.
Deeply grateful, my lord. Obliged, much obliged.
But if the registry will be directed to.
It will be done within the, by this day, absolutely, it will be done. First type or, yes, yes,
If we can advance and we can get the release.
yes, absolutely.
Much obliged. Deeply grateful.
Next,
Item number 5, WPS 339 of 25.
And for the response number 1.
And for the 3 lots.
yes.
We are directed. For 4 lots.
Yes. Official respondents were directed to come back with a report. Where is your report?
Lots.
There's such concern, there's such concern is having their own. Because, they have. They have given the report on the basis. Of inspection being done by the decision.
It's an incomplete report. Column 18 is incomplete. Yes, where is the other page? Oh, it's here. It has been folded. I'm sorry. Yes, it's there.
Madam.
Yes, so nothing further remains.
And will be finding an exception. That as for our information, my lord, they have not included the subject line. Without visiting that they have submitted. So I think that will happen to pay before the next circuit, which makes them follow the exception.
Very well. Yes, that's the issue. Anyway, if she wants to continue, so be it. I've seen that, and this is 55/1, yes. Maybe they're adjourning plots, that's, yes, and they have been demarcated also. After this report, I do not know why you want to come back with an exception. How will that help you?
Before visiting the subject line, they have some.
Yes.
That's only that.
Yes, 51 was visited, no construction was found, nothing else. No need to carry this forward to the next circuit. Report submitted by your respondent number. First respondent is taken on record. Paragraph, it appears from the report that no construction work is being carried on in survey number 51. Stop. The private respondent is carrying on construction work in survey number 55/1, which is not the subject matter of the suit. Paragraph, learned counsel for the petitioner seeks to use an exception to the report. Paragraph, the matter be placed before the next available circuit bench. Petitioners.
Obliged, lords.
Next.
Item number 6. 348 of 2025.
Transfer certificate.
Yes, I'll
Yes.
respond to number 2.
Not today, going to resolve it, we are.
You're trying to resolve it. Very good. Let me record your submission in that case. And let it be before the next subject. Monday. Very well. Very well. And it's you are the state, right?
Correspondent number 1, school principal. Sir.
Learned counsel for the only one respondent.
No, 2 respondents.
Your respondent number?
I'm for 2.
One.
Sir is for 1.
Learned counsel for the first respondent seeks accommodation on the ground that the school is trying to resolve the issue. Paragraph, let the matter appear under the same heading on 11th August.
Can be disposed.
Next.
Item number 7. WPA 356 of 2025.
I'm hearing for the petition.
And for the respondents.
Yes. What's the issue?
Page 21, the notice under section 104, the order passed by the Tehsildar under section 104, they have illegally enclosed a footpath, my lord.
Oh, it is that matter.
Yes, my lord. And the complaint was received from the Pradhan, the said Gram Panchayat.
The logic that actually
Where-
here is that footpath wherein the petition has been alleged to have constructed something unauthorized manner that has not been demarcated. And on the last occasion, your lordship had observed that, and your lordship had passed an order directing the respondent authorities to first demarcate, and if at all they find anything, they can carry on with the process. But till now, the demarcation has not been done. The area of the footpath, and because the land of the petitioner is adjacent to the footpath, so that demarcation has not yet been carried out.
Has the review application been disposed of?
No, it is still pending, my lord.
It is
Why don't you dispose of the review application?
We can dispose of. Because it is still pending, they have preferred this writ application.
until the disposal, your lordship.
But there was no stay.
There is no stay.
This order itself is very clear. I think this petition can be disposed of.
My,
The respondent authority shall not take any steps with regard to survey number 193 by 1 by 1. That is your land. However, is at liberty to implement the order impugned in respect of 193 by 1 by 9
Your lordship, but the-
upon demarcating the said property in presence of the petitioner or her representative. Has that been done? That has also not been done.
well, notice, demarcation notice has been issued to all the parties, my lord, and.
When? After this order?
petitioner has
Yes,
not received-
After July 31? Please show me that the order has been served. The notice is served.
Right now, the notice, because since it's a of matter of Swaraj Deep, my lord. It takes some time. What is in the
Yes,
record.
this order is on 31st July.
Yeah.
After that, adjourned for the day, adjourned for the day. Yesterday also it was adjourned
And,
for
all the
the
records
day.
are with the Patwari concern.
Yes, so after 31st July, today we are on 8th August.
My lord.
Sufficient time, a week you've got.
Next, on Monday, your lordship, until then the clarification.
Or there been order that till this review application will be disposed of within a time frame. So that we can dispose the review application.
Because in the absence of circuit, if something happens in petitioner.
No, it is.
No, there is this court has directed implementation of the order in a particular manner. So if I stay the order and direct implementation, how does that happen? It is already recorded that it can be done in 193 by 1 by 9 after demarcation. So let me dispose of the writ petition on
Yes,
stating
ma'am.
this
Yes.
on this score.
Yes, ma'am. That can be done.
Clear in that time.
What instruction do you want to have to
Your
take?
lordship, whether this has to be disposed of at this stage or not, your lordship. Let this be fixed on the day, your lordship.
Disposal doesn't depend on anyone. The court has to decide whether it has to be, can be kept.
Certain facts, your lordship.
Whatever my lord has passed an order, that can be
final.
Yes,
final
yes, that
can be-
actually, yes.
Because review is also.
Because nothing else, no.
Because on the earlier date, there was a direction to serve the copy. That's why the application was not disposed of. Now that she's appearing, I think this order can be finalized.
Fine.
That will solve your purpose also.
It's also pending.
That can be disposed within a time frame. My lord can pass an order.
Review is with regard to your land.
Your Lordship, the
There
entire-
cannot be a review on the footpath.
Your Lordship, the order is in review because because the whole order, that whole process was done without any opportunity of hearing and without.
No, no,
Now
no,
doesn't
now
say-
we will not say that.
The order doesn't say so.
It, now.
It's
they cannot
recorded,
say
you were served with notice and you did not
whatever
appear.
any other matters, my lord. In this matter, my lord, it is clearly he has stated that she appeared along with the documents, but she could not.
Prove her case, yes.
In that regard, Your Lordship, there are averments in my writ petition as to why I could not appear.
You have appeared. You could not,
Maybe in other
I have
matters,
not appeared,
they
Your
can.
Lordship.
the respondent failed to appear, did not appear. Failed to appear or establish any legal right over the property. What are your specific reasons? Please show me. For not appearing?
Notice was issued.
Paragraph?
Your Lordship. From paragraph 6, Your Lordship. That upon going to the said notice, the council, Your Lordship, what has happened is, when the notice was served, that was actually received by the son of the petitioner. The son of the petitioner is also not much educated, and the problem is, Your Lordship,
But they
there is
reside
an
in the
issue
same house.
between the Pradhan and the petitioner, which is continuously going on, and there are regular notices which are being received. So he was not much careful in that regard, and he misplaced that notice. The petitioner was never given that notice by hand
That's-
to her directly. And the
that-
petitioner.
that is
Stay in a
immaterial,
separate
sir.
place.
Your
That is
Lordship,
Yes,
immaterial.
sir.
You are aware of that as a student of law.
Your Lordship.
It was received, despite which did not appear, an order was passed, no documents, so what order I have passed is sufficient
Your
to
Lordship,
protect you also.
But my reason for non-appearance that I have mentioned in my review.
That doesn't really matter.
Your Lordship, but
What matters is the non-appearance. You've received a notice and yet not appeared. And there's a clear direction that 193 by 1, nothing will be done on that land. Only please see this order. Now that you're here, I think this,
Your Lordship has passed.
that is a perfectly, I mean, that can be finalized.
Yes, Your Lordship, that can be finalized. But Your Lordship, only one thing, that in accordance with law upon demarcating the said property.
Yes,
In the
yes,
presence of the petitioner,
yes.
after issuing a notice.
Representative has stated that.
Yes, after issuing a notice, Your Lordship, what is happening? They are suddenly coming, after this order was passed, they suddenly came to the premises. We will demarcate now. That should not, after issuing a notice, so that my person, my surveyor also can be present there. After issuing
Very
a
well,
notice.
very well. Issue a notice, let it be in presence of the petitioner.
And one more thing, Your Lordship. That Your Lordship has passed the order, however, the respondent is that because both the lands are adjacent to each other. 193/1/1 and 193/1/9. Both are exactly adjacent to each other. So, Your Lordship, however, the respondent is at liberty to implement the order included in respect to this in accordance with law upon demarcating the said property and survey number that. Both the land may be demarcated. Because demarcation only if that is done, a clear picture will not be there. Both the land, my land also may be demarcated, that footpath also may be demarcated. Because that only they can.
No, madam, let the footpath be demarcated, that will automatically demarcate your land. If they say that this is the footpath area and they do their work on that, you cannot get your property demarcated in the garb of the footpath being demarcated. No, that will not be done.
I'm asking for demarcation, Your Lordship, 1 minute. They are saying, because our plea, what is our plea, Your Lordship, that we have not encroached any part of the footpath. That is our point. The footpath and my land is exactly adjacent to each other.
That's the reason why the footpath will be demarcated.
Yes.
So your land doesn't need to be demarcated separately. If the footpath is demarcated, the footpath is carved out of that land.
That's what, Your Lordship, if my land is not demarcated, what they will say, that this is the breadth or this is the length, my area will be reduced. If suppose, Your Lordship, the problem is with regard to the breadth. The sketch map which was prepared.
Madam, out of the record, you are aware what has happened. This happens very frequently. Little bit of land, okay, let me extend my courtyard to
Yes,
that
yes,
much.
I know, your lordship.
So let only the footpath, we are all human beings with practical approaches.
This is my class.
So
Said, your lordship, if proper demarcation is done, they will demolish, your lordship, they themselves will demolish.
so the only the footpath needs to be demarcated, not his, not
Right.
her land.
By issuing notice letter.
Absolutely, absolutely. By an order passed on July 31, 2025, this court directed the respondent authority not to take any steps with regard to survey number 193 by 1 by 1 occupied by the petitioner. The respondent was granted liberty to implement the order impugned in respect of survey number 193 by 1 by 9 in accordance with law upon demarcating the said property in presence of the petitioner or her representative. This court adds that such demarcation shall be made upon service of notice upon the petitioner and in presence of all concerned, including the petitioner slash her legal representative. In accordance with law. Since nothing further remains to be adjudicated in the writ petition, the same is disposed of. There shall however be no address to costs since no affidavits urge a certified website.
Okay, only one thing, lordship. I filed a review application. 7 days have expired. The lordship has directed within 7 days my review application will be heard and disposed of. Till today, your lordship has not been done.
Yes.
The construction work has been delayed for some.
The authority is further directed to consider and dispose of the review application within 7 days from date.
Within 2 weeks.
7.
This is before
When the order
it आगे होगा, हाँ? Dispose of it आगे.
Madam.
Okay. Right.
Anything else?
One more matter, my lord, item number 15, my lord, I have already filed my opposition before the registry, my lord.
Oh, I've got it and the petitioner wants to come back with a reply. I've recorded that. I've recorded your opposition, yes, and have granted liberty to the petitioner to come back with a reply.
My lord, my appearance will be recorded, my lord.
Your appearance.
Thank you.